Justice Sotomayor?
Bad facts make bad law, and I fear we may be headed that way. Justice Gorsuch started with the right question. We know there are abuses of the forfeiture system. We know it because it's been documented throughout the country repeatedly of the incentives that police are given to seize property to keep its value, as opposed to issues of probable cause or issues of legitimacy of the seizure, okay? We also know that that incentive has often led to months, if not years, of retention of property that ultimately gets returned to the owner because there was either no probable cause or because of the innocent owner's defense. So the question before us is, if we make a determination to take the dicta in Van Neumann and in the 8-8 whatever case, all right, to say that's the entire process you're ever due, do we leave open the possibility that there are states, jurisdictions, that are abusing this process and not leaving us any arms to correct it? That's what we're doing, isn't it? If we say there's no overriding first question, is this process, the features of this process, are they enough, whether it's under Matthews or Barker, then what we're basically saying is go at it, states. Take as much property as you want, keep it as long as you want. Let's hold out no hope whatsoever that there's ever going to be any further process that's due. That's the bottom line, right?
I think that's right, Justice Sotomayor, and I think that the court should hold here that Matthews is the way to analyze
I know that's what you want, but the point is
Yeah.
that if we take that dicta in a case where none of the process itself was at issue, it was separate process that was at issue, or timing of that process, none of the features of the process is at issue, as binding on us, we're throwing up our hands and say due process does not give people any protection whatsoever under any set of circumstance.
I think that's right, and I think the court shouldn't do that here, regardless of the facts. I also think on the facts, and I don't want to wear out my welcome, but I also think—
You are wearing out your welcome, because I like Justice Jackson, that's not the question before us, whether the process here was enough or not.
That's right. I do think that there are explanations for the timeline that took place in this case, but the court doesn't need to reach that. All the court needs to decide here is that von Neumann and 8850, as you say, Justice Sotomayor, didn't foreclose any and all potential due process claims that one might bring, and Matthews is the way to think about whether additional process is due in this context.
Now, after Crimstock, there are jurisdictions that have looked at these issues under the Matthews test and not required retention hearings, correct?
Right. There are different ways in which states might potentially satisfy due process. It doesn't absolutely have to be a retention hearing.
That's what I'm saying, which is it depends on each state's assessment of the factors that Matthews looks at, correct?
That's right.
And some have not, some have required others, given the uniqueness of their jurisdictions, correct?
That's right.
Thank you.